You do have it on mute for you, not mute for them. You muted your own stuff. I want to hear it.
Good afternoon. Come on in and get a seat. Thank you for coming. I'll just go over a couple of things. If you have a cell phone, if you could please turn it down or mute it, it'll be greatly appreciated. People on Zoom, you are muted. Please stay muted until the end of the talk. And then if you have a question for the speaker, put it in the chat, and I'll be monitoring the chat, and we can ask the speaker your questions. Danaya is here, and she is going to introduce our speaker for today.
All right. Thank you all for coming. I see people are coming in right on time. I am pleased to introduce this week Professor Tracey Maclin. He is the Raymond and Miriam Ehrlich Eminent Scholar Chair at UF. He came to us from Boston University just a few years ago. He teaches constitutional law and criminal procedure, I believe. Criminal procedure, right? Yes. He's also taught at Cornell Law School, where 1 or 2 years ago, he was my professor, one of the best professors I absolutely have ever had. And he clerked for Boyce Martin of the U.S. Court of Appeals for the Sixth Circuit, and is a graduate of Columbia Law School and Tufts University. So with that, he's going to talk to us about the birthright citizenship issue. I suggested he could talk about all of the Supreme Court cases that came out this term, but really they're kind of boring this term. But and then this particular case is what, 150 pages long. So trust me, it'll be great. Thank you.
Thank you for that kind introduction. Although Danaya called me about a week ago, and as she just indicated, she said, Tracey, I want you to come and give a talk about the Supreme Court cases this term. And I immediately asked her, I said, well, who died? Because you don't start preparing for giving a talk in a week. And then she explained to me some of the complications, and I said, I'll be happy to talk about birthright citizenship. And Danaya is right. That decision named Trump versus Casa focused on the nationwide injunctions that several lower federal courts had issued against President Trump's executive order on birthright citizenship. But the court did not address the merits of Trump's order. And Danaya is right. The discussion on birthright, the discussion on nationwide injunctions is 120 pages long. And that would have taken me the week to read. So I'm not going to talk about nationwide injunctions. I'm happy to talk about birthright citizenship. Now, I think the first question for all of us is, can the president, or for that matter, Congress, end birthright citizenship for children born in America to the parents of undocumented persons? Now, we know, and this was back in his first term, but we certainly know now that President Trump wants to end birthright citizenship for the children of undocumented persons. He tried to do it via an executive order, but again, several lower federal courts ruled that that order was unconstitutional and issued nationwide injunctions preventing the enforcement of that order. Now, the Trump administration appealed to the Supreme Court, but they did not. They did not ask the court to review the merits of the birthright citizenship issue. What the court did do was rule that nationwide injunctions exceed the authority of lower federal courts, but said nothing about the merits of President Trump's order on birthright citizenship. Now, alternatively, the president could achieve his goal of ending birthright citizenship by persuading Congress to enact a statute defining who is a citizen of the United States. The Republican majorities in both the House and Senate, we know, or at least in my view, have functioned like high school pep rally teams rather than members of an elected independent branch of the federal government. They seemingly have given President Trump everything he wants during his second term. Presumably, they can do the same thing here. If Congress passed a statute saying that a child born in the United States to undocumented persons was not a citizen of the United States, would that statute be constitutional? And Congress would be using what is known as its Section 5 powers. The 14th Amendment has 5 sections. At the fifth section, at the end of the amendment, gives Congress the power to enforce by appropriate legislation the terms of all of the 14th Amendment. They would be using their powers under Section 5 to enforce Section 1 of the Citizenship Clause, which I'm going to mention in a moment. Put differently, does Congress have the constitutional authority to define who is within the jurisdiction of the United States for purposes of Section 1? Now, many of you know, I'm sure, that the concept of birthright citizenship was a reaction to the Supreme Court's decision, some would say infamous, to the court's decision in a case called Dred Scott versus Stanford, which was decided in 1857. Some say helped trigger the Civil War. Dred Scott ruled that no black person, free or slave, could be a citizen of the United States or part of the national community that is known as the United States of America. The framers of the 14th Amendment intended to overrule Dred Scott, which they did in the Citizenship Clause of Section 1 of the amendment. That clause states, and I guess I should apologize, I'm kind of an old school professor. I believe that students should be scared of their professors. And I don't use a whole lot of PowerPoint or slides, so I should have this up on a slide. But the Citizenship Clause states, and I quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That is the first sentence in the 14th Amendment. Today, birthright citizenship is the policy whereby children of illegal undocumented persons born within the geographical territory of the United States are entitled to American citizenship. Critics of birthright citizenship, like President Trump, contend that it is a magnet. It is a magnet for illegal immigration into the country. Now, prior to the Civil War, did the Constitution define citizenship? Because before we had the Citizenship Clause, what was the state of the law? The answer to that question is no. While the original Constitution mentions the term citizen several times, it did not define. The original Constitution did not define citizenship or who was an American citizen. Before the Civil War, the states, not the federal government, the states determined who was a citizen, and the rules varied across the nation. Massachusetts, Danaya mentioned, I spent the last 35 years up at Boston University Law School. Massachusetts, for example, recognized free African Americans as citizens. We know, of course, many other states did not. Only after ratification of the 14th Amendment did the Constitution, only after ratification of the 14th Amendment did the Constitution provide a national definition for federal and state citizenship, which it did in the Citizenship Clause. Now, what does the clause require? What does it take to become a citizen of the United States? According to the text, and that's the first place, at least in law school, some of us require our students to look at. All right, I assign my constitutional law class, I assign the students to read the text of the Constitution. And that's probably the last time they'll look at it, but I do assign it. Now, according to the text of the Citizenship Clause, there are two components. There are two components to American citizenship. One, birth or naturalization in the United States. And two, being subject to the jurisdiction of the United States. Today, the traditional prevailing view of the clause is that anyone born within the geographical limits of the United States is automatically a citizen. You're born in the United States, you're a citizen of the United States. Now, this is also the view, of course, shared by critics of President Trump's view on birthright citizenship. Now, are the critics of the president correct when they say, look, all it takes is to be born in the United States? You're born in the United States, you're a citizen in the United States. Are the critics right? Now, according to the supporters of the president, and maybe even the president himself, I'm not so sure how much he's actually studied the issue, but let's give him the benefit of the doubt. According to the supporters of the president and President Trump, the liberal and traditional view of the clause renders the jurisdiction language of the clause utterly superfluous. Right? The traditional liberal view, which says, born in the United States, you're a citizen, that makes the jurisdiction clause superfluous. If that had been the intention of the framers, so the critics argue, if that had been the intention of the framers, presumably they would have simply said that all persons born or naturalized in the United States are thereby citizens. Didn't need to add the jurisdiction clause. Supporters of the president make a good point, and I was told that this is being recorded, so I'm now on record as saying that the president has a good point, at least on some things. Now, the jurisdiction clause must have been something to the framers of the 14th Amendment. However, and this is what lawyers are fond of doing, they make a point on one side and they say, well, on the other hand, all right. On the other hand, even when we interpret the phrase subject to the jurisdiction strictly and independently of the first part of the clause, why should we conclude that undocumented persons are not subject to the jurisdiction of the United States? A person who enters the country illegally or who enters lawfully but overstays his or her visit and they live and work among the civilian population, that individual, come in illegally or overstay their visit, certainly can be held criminally and civilly liable under American law enforcement for their actions while in the country. In other words, if a person has a visa and he's here or she's here from France and they overstay the visa and they come in and they burglarize my home, they can be prosecuted, right? And if they commit a federal crime, they certainly can be prosecuted by the federal government. They are certainly within the jurisdiction of the United States. Undoubtedly, they are subject to the jurisdiction of the United States. So even if we interpret the clause strictly and independently, they're still subject to the jurisdiction of the United States. Now, it needs to be said, however, that two legal scholars, have argued that the Citizenship Clause did not address, much less resolve, the question of citizenship for the US-born children of undocumented persons. Well, why didn't it address it or resolve it? Well, according to these two scholars, the federal government was not in the business of restricting immigration in 1866, right? We had open borders. If you can get across the ocean, get across the Rio Grande, you're in. And so they argue that the clause never thought about and certainly never resolved the question that is bothering everybody today. Now, there's a response to that, but we'll leave that maybe for the Q&A. Another point to take into account is what was the impact, and Danaya, you'll cut me off if I need to be. She couldn't do that when she was a student, but she can do it now. What was the impact of the Citizenship Clause on Native Americans? What was the impact of the clause on Native Americans? A little bit of American history. During the Senate debate over the 14th Amendment, Senator Jacob Howard, who was the author of the Citizenship Clause, he attempted to assure his skeptical colleagues that the clause was not intended to make Native Americans citizens of the United States. Native Americans, Senator Howard conceded, were born within the national geographical limits of the United States, but he steadfastly maintained that they were not subject to the jurisdiction of the United States because they owed their allegiance to their tribes and not to the United States government. They owed their allegiance to the tribes, not the United States government, so they were not subject to the jurisdiction within the meaning of the clause's text, and thus were not citizens, even though they had been born in the geographical limits of the United States. Indeed, Senator Lehman Trimble, who was the chairman of the Judiciary Committee, supported this view, and he argued that subject to the jurisdiction meant not owing allegiance to anybody else and being subject to the complete jurisdiction of the United States. Now, Eric Foner, who some of you may know, was the eminent scholar, professor at Columbia University, the eminent scholar on the Civil War and Reconstruction. Foner contends, that members of Congress during the debates on the 14th Amendment made clear that the phrase subject to the jurisdiction thereof applied only to Native Americans living on reservations. All right, and of course those reservations were considered separate sovereigns, right? They were their own nations. It applied only to Native Americans and to American-born children of foreign diplomats, okay? According to Foner, these are the only two exceptions recognized by the Citizenship Clause. Now, despite Foner's analysis, and I would be the last person to question it, a third exception to the Citizenship Clause has been offered, all right, and that is children born of foreign invading soldiers, all right? So if a foreign couple is over here and they have a kid, all right, that child, albeit born in the United States, would not be protected by the Citizenship Clause. Now, These three exceptions make sense. Foreign diplomats, we know, have diplomatic immunity, meaning that they are not subject to the jurisdiction of the federal or state law enforcement. So if some diplomat from France commits a crime, rather than being sent to the pokey, they put him on a plane and they send him back to Paris because he's got diplomatic immunity. Invading or occupying soldiers are not subject to the federal or state jurisdiction as a practical matter because they're occupying the country. And finally, when the Citizenship Clause was ratified, Native Americans, again, were subject to tribal jurisdiction. They had their own nations. They were considered separate sovereigns. Now, has the Supreme Court addressed this issue? There has never been an explicit holding by the court that the children of undocumented persons are automatically accorded birthright citizenship. In a case called United States versus Wong Kim Ark, 1898. 1898, the court ruled that a child born in the United States of lawful or legal, child born to the in the United States of legal aliens was entitled to birthright citizenship under the 14th Amendment. Right? The court held that Mr. Wong Kim Ark was a citizen of the United States because he was born in the United States, even though his parents were, quote, subjects of the Emperor of China. The court exhaustively surveyed the common law origins of birthright citizenship, the history of the Citizenship Clause, and contemporary interpretations of the clause's scope, and concluded that the effect of birth is declared by the Constitution to constitute a sufficient and complete right to citizenship. Now, in dicta, meaning it was just making passing remarks, the court recognized two exceptions in which the United States could not apply its laws to foreign nationals. One, again, children born of alien enemies in hostile occupation, and children of diplomatic representatives of a foreign state. Now, just so there's no doubt, Wong Kim Ark was a controversial and a split decision. It was a 5-4 opinion, which provoked the dissent of Chief Justice Melville Fuller, who argued that contrary to the majority's reasoning, 14th Amendment did not, in fact, adopt the common law understanding of birthright citizenship. And it's also important to concede that Wong Kim Ark did not address the question of whether children born to undocumented persons illegally in the country, were protected by the Citizenship Clause. Again, Mr. Ark's parents were lawful residents, albeit not citizens. They were lawful residents at the time that Mr. Ark was born in the United States. Now, did Congress need to amend? Did Congress need to amend the Constitution before offering citizenship to all Native Americans? Again, when the 14th Amendment was adopted, there was near unanimity among the framers that the 14th Amendment did not extend citizenship to Native Americans, right? No doubt about it. Nobody argued otherwise. Although, again, born in the United States, Native Americans were not subject to the jurisdiction of the federal government, so they were not considered citizens of the United States. Beginning in 1870, however, Congress began to pass legislation offering citizenship to Indians on a tribe-by-tribe basis. Finally, in the Indian Citizenship Act of 1924, that act provided citizenship to all Native Americans. Any Native American who consented, to become a citizen, all right, or I'm sorry, any Native American could consent to become a citizenship, could consent to become a citizen, period. All right. Thus, Congress used its legislative authority under Section 5 of the 14th Amendment, which I mentioned at the top, to determine who was within the jurisdiction of the United States to become citizen. Now, supporters of President Trump argue that Congress could make a similar determination today based on this legislative precedent, and Congress could say that children born in the United States to undocumented persons are not subject to the jurisdiction of the United States. I mean, what else are they doing, right? They could pass a law that says those children born to undocumented persons are not citizens of the United States. Case closed, okay? And according to the supporters of the president, a constitutional amendment is no more required today than it would have been required in 1924 when they passed the Indian Citizenship Act of 1924. Also, and again, I didn't record it, but I'm going to say it, supporters of the president make a good point when they contend that it is illogical. It's illogical to believe that the framers of the 14th Amendment intended to confer the benefit of citizenship, that they intended to confer the benefit of citizenship on the children of undocumented persons when they explicitly denied that same benefit to Native Americans who had been born in the United States. Pretty good argument. Pretty good argument. Not saying it's a killer argument, but a good argument. And they go on to point out that undocumented persons who defy federal law by coming into the country illegally should not be allowed to confer such an advantage on their children. This, they argue, would not be visiting the sins of the parents on the children, as is often claimed, since the children of undocumented persons born in the United States would not be denied anything to which they otherwise would have a right to. Okay? So that's what the supporters of the president say, and that's what they tell the president to say. And then a final point. Supporters of Trump, give him his due. Supporters of President Trump concede that those who already have been granted birthright citizenship, despite being the children of undocumented persons, they cannot be stripped. They cannot be stripped of their citizenship. Well, why not? Well, equal protection considerations, which is also part of the 14th Amendment, would counsel that citizenship, once granted, is vested and cannot be revoked. The proposal offered by President Trump and his supporters to end birthright citizenship is prospective only. Prospective only. You can't claw back like they've done with NPR and public television. You can't claw back citizenship. So that's the argument on both sides. I'll wait till somebody asks me what my view is, but I hope that was informative, and I'll leave it for questions and answers. Is that enough time, Professor Wright? Yes, sir.
I'm not supporting Trump's view, but just for the sake of argument, if we did accept Trump's view, would that also apply to people that are deceased that were born of undocumented immigrants? Even if you're not alive today and you are considered to be a citizen today, according to Trump, but if you were born, if you know that person who's deceased was born from an undocumented immigrant, then he's not really a citizen. He or she is not really a citizen, according to Trump. Would that be correct?
Well, again, their position is that it's prospective only. So if the dead person that we're talking about, he would be considered, or she would be considered a citizen. And so they could say to you, oh, our proposal has no effect on them. There's no effect on them. Now, I'm trying to imagine, I mean, I'm thinking, what are you concerned about, the Social Security benefits or some test date problem that would arise I mean, is that where was that what prompted
That
the
would be
question?
a part of the problem. The other part of the problem would be if those deceased people are considered not to be citizens, then what about their children? Then their
Well, their
children.
children, okay. Their children would be born in the United States. Right. Yeah, I see. Okay, I see your point. I see your point.
It could
I thought you were worried
cascade.
about those dead people would be voting. No, that's a fair, it's a good question. That's a fair point. No, but the Trump people would say to you, it's prospective only. So if they were considered citizens at the time of their death because they were born in the United States, they remain citizens, even in death. Even if their parents were undocumented. Right, right, because they know they would run into serious equal protection problems to try and claw back. They can't do that. The equal protection. Even, I want to say even this court, and I'm looking at Professor Wright, you got to understand, and I say this now in all seriousness, this Supreme Court, our current Supreme Court, is without a doubt the most conservative Supreme Court, I think, on record. I'm sorry? Yeah, I think so. But certainly more political. More political. So, but I don't think they would, even this court would allow them to claw back, apply their position retroactively, which is what I think you're talking about. Now you're laughing again. You laugh when you started the question, you're laughing at the end of the question. What am I missing?
Just the absurdity of that line.
You know, I mean, Danaya and I, we were talking about it with Dale at lunch. He's just doing what he said he was going to do. American people voted for him. So, I mean, they may not have had this issue in mind, but he's doing what he said he was going to do.
This is a fascinating conversation, and I'm very curious. There are a lot of immigrants who are married to American citizens. How would they treat that?
Are you referring to the person who's married to the citizen, or you're referring to their children?
Their children.
Well, again, how would I treat it under Trump's proposal, or how are they treated today under the law as it exists? As it exists today, they're considered citizens. Now, Trump's proposal, that again, another great question. I don't know. I don't know the answer to that.
Now, what we'll attempt to do as previously, we'll try to alternate back and forth and also take the questions from
Can I give
online.
Wright's reaction to that? You heard the question, right?
I did. I was just going to say something. I do believe that if the mother is the citizen and the father is the undocumented parent, the citizenship of the child may be different, the automatic citizenship of the child, than if the father is the citizen and the mother is the non-citizen.
Well, but, I mean,
At least historically, that was the case. I don't know, honestly.
there
if
have
it's
been
still
some
the-
Supreme Court cases dealing with that issue for children born abroad. Okay? And they have one problem is you're not supposed to be making the benefits or rights turn on the gender of the person. So if they say, well, if the mother is a citizen, but the father is not, we'll give you citizenship, but if we switch it around, that would raise, again, equal protection problems along gender lines, which they can do sometimes, but they're not supposed to be doing that. But those cases, and the courts had a number of cases on that issue, but they all involve children born outside the United States. I'm assuming your question is based on the premise that the child's born in the United States. And then they would have, again, problems in my eyes having it turn on the gender of the parent.
Several months ago, there was talk about rescinding Elon Musk's American citizenship.
Let's get a show of hands.
How, and that was coming from the Trump camp, how did they plan or did they articulate what they were going to base that on?
They can't do that. They can't. So Trump's advisors know, despite what, was it Stephen Smith? What's Smith's first name again? You know what I'm talking about.
Stephen Miller?
Oh, Miller, excuse me, right. Stephen, Miller knows better. You cannot revoke a person's citizenship. So, even as much as some people would like to see must go back, Trump can't do that. Certainly Trump alone can't do that. Congress can't do that. So that's not going to happen. Period. That's not going to happen.
We have a question on Zoom.
June, I see you have your hand up. Do you have a question?
Yes, well, I understand that you can't claw back, which is good news. But my parents came to this country as young children in 1916, I think it was. They lived here. They grew up, went to school, got jobs, and were in their, got married, and they were 30 or 31 when they then applied for citizenship. And I was born before they made that application. Would they have been considered illegal immigrants at that time?
The first part of your question, you said your parents came over when?
When they were children in 1916.
Listen, I'm not enough of an expert, or I'm no expert on the immigration laws. So I don't know what the immigration laws were at that point in time. I'm assuming that they arrived at Ellis Island or some other place and
Right.
were welcomed in. So yeah, my guess would be that they're citizens. We didn't have the same restrictions that we have today. Again, we had open borders for a long time, and the first restrictions on immigration were directed at the Chinese. And that was all based on prejudice and bias, mostly from California and the Western states. But that was the first restrictions on immigration. And then we know we had subsequent developments in that area. But again, I'm just not enough of an expert to.
All right. And secondly, I'd like to mention that I lived in El Paso, Texas for many years. And it was quite normal every night to hear the sirens go off as the pregnant Mexican women crossed the Rio Grande, which was a drizzle, and had their babies in El Paso. And then so that's the problem that we had for a very long time. I don't know what they've done about that, or is that part of this birthright thing that now that child would not be an American, or under the present law, would that child be an American?
Right. Well, I thought you were going to say that you were born in Texas and that makes you a citizen of a foreign country, because
No.
everyone tells me Texas is its own sovereignty, but
Right.
I have what may intentionally be a complex question. The first part of the question is whether duration of time spent in the United States behaving and performing and being accepted as a de facto citizen has any relationship to this set of laws. And the second question is to try to muddle that a little bit more by adding into that situation multiple generations of intermarriage with people who were not considered citizens at the time or may not have been, such as Native Americans. There certainly must be hundreds or thousands of people who are 3/32 Navajo or something like that. And whether there's a percentage of how much whatever you want to call people who think of themselves as American citizens who have all sorts of mixed lineages. Puerto Ricans could be easily
Well,
be
no,
included.
That's muddling it up a little bit too much. Puerto Ricans are considered American citizens.
But they are, but some of them don't think so.
No. Let me answer the first part. The quick answer is no. Duration doesn't matter. Okay, that's just to make that clear. And there's no such concept as a de facto citizen. I said there's no such concept as far as the law is concerned as de facto citizen. Either you're a citizen or you're not. Okay. Now your second point, I'm not sure that's a legal question, but again, I'm going to rest on my answer to the first part, which is you're a citizen or you're not. And who you're married to or how much this type of blood or that type of blood you got in you, none of that matters. None of that's matter. Doesn't matter. Doesn't matter. And that was one of the points of the citizenship clause. Because, go back to the Civil War, there's a case called Plessy versus Ferguson, famous case in which the Supreme Court upheld segregation. In that case, segregation of the railroads in Louisiana. And Mr. Plessy argued that he wasn't black because he only had a certain amount of Negro blood in him. Didn't matter to the Supreme Court. So the citizenship clause was meant to put an end to all that complications and frankly nonsense. Does that answer the question a little bit?
I don't know what happened to the mixed race black man.
Well, nothing happened to him. There's still some out there.
Yeah, quite a few, and I think.
They got a few mixed race white men too.
Was he considered a citizen?
What's that? Absolutely. If you're born in the United States, again, that was the point of the clause. If you're born in the United States or naturalized in the United States, you're a citizen. We're not going to count how much blood you have or how much of this blood or that type of blood you have. You're born in the United States, you're in. Right? Like if you, back in high school, you remember the football team, you're in to all the parties. Doesn't matter whether you're invited or not. Not enough high school
I would
football
argue
players.
that, are you ready? Okay. I would argue that the definition of documented or undocumented is up for grabs also, because many Americans believe that undocumented means there's no record whatsoever, but it also includes, for example, people who are admitted, documented as with student visas, the visas run out, and then they are classified as undocumented. But there is an official record of them in the federal government has those records. So what does undocumented really mean? And if you argue that it's a coverall, an umbrella, I think you'd have a tough fight in the courts with that, or the administration would.
I tend to agree with that. Again, I'm going to point out I'm not an expert in immigration law. Undocumented persons, the phrase undocumented persons is a catch-all, as you point out. It's also been a phrase used when the Supreme Court was deciding a lot of these cases prior to the last few years. They often used the term, and in fact, almost always used the term illegal aliens. And that was because folks were in the country illegally, and they were an alien. Either you're an alien, a non-citizen, or not. And so there were some lawful aliens, people who had green cards and other authorization to be here, or not illegal aliens. But you're right, undocumented is a catch-all phrase that's used now, but could encompass a lot of different subjects.
Well, if somebody's here on a tourist visa, for example, they're a legal alien. If the visa runs out,
Yeah.
the next day they're illegal aliens.
Absolutely.
So these are, again, the kind of terms that are misused to turn people and divide people.
Absolutely.
And I would finally submit that the only way they can, because the wording of the amendment is very clear, and it'd be very difficult, I think, for even a Supreme Court judge to deny the language. But it would take an amendment to the Constitution to accomplish what the administration
Well, I'm
wants.
going to push back on you there a little bit, because the Trump people say that subject to the jurisdiction language or phrase means something. And if you're in the country illegally, you're not necessarily subject to you're subject to the jurisdiction of Guatemala or Sudan or wherever else you're coming from. Now, the problem they've run into, of course, is, okay, you're saying we're not subject to the jurisdiction of the United States. Well, if I commit a crime, if I'm in the country illegally and I commit a crime, you can't prosecute me? Of course not. Of course you can prosecute that person. That person is subject to the jurisdiction not only of the federal government, but of the state government in which he or she commits a crime. So they can't have it both ways. They can't
We're
say,
talking about the child, not the parents.
no, I'm talking about anybody. No, I'm talking about anybody. I'm talking about anybody who is in the United States unlawfully. That person, if I'm a French citizen, I'm a citizen of Haiti, and I come to the United States illegally, or I overstay my visa, I can't go commit a crime and not be subject to the jurisdiction of the federal government or the state government. Of course I am, even though I'm in the country illegally. Now, the Trump people would say, well, with the children, that's different. The parents are responsible for them being here. Now, again, they can't have it both ways. They can't say, well, we can prosecute the parents because they're subject to the jurisdiction, even though they're in the country illegally, but the children somehow, and the parents themselves can't be prosecuted? No, can't have it that way. And plus, all right, now, the Trump people, they don't really want to acknowledge this, but when you are arrested or detained for being in the country illegally, you're supposed to have due process before they boot you out. Well, why is that? Because you're subject to the jurisdiction of the United States. Being subject to the jurisdiction of the United States means you're entitled to certain procedures. And that means before we can throw you out of the country, we got to give you a little due process.
But the child of those, no matter, even if they're two gang members, the mom and dad, the child is innocent and is a citizen no matter
Well,
what.
that's true. That's true. But, you got problems about, well, the child can't make decisions on their own and so on and so forth. But the best case to support what you're saying is a case called Plyler versus Doe, which was I want to say late 1980s case where Texas, the sovereign nation of Texas, all right, said, we're not going to give free education to the children of undocumented persons. All right, we're going to let them come to school. They can go to the schools, but they have to pay tuition. And the Supreme Court, the Berger Court, said, no, you can't do that. Even though the parents are in the country illegally, you cannot treat the children differently. Now, they gave some reasons that one can argue with. To me, the best reason behind that case comes from the old illegitimacy cases, all right, which I'm not supposed to call them that anymore, right? But the illegitimacy cases of the 60s and the 70s, and the Supreme Court said, look, when states treat children born out of wedlock differently from children who were born legitimately, that violates the Equal Protection Clause. Why does that violate the Equal Protection Clause? Because the illegitimate children, you shouldn't penalize them for something they're not responsible for something that they cannot control. And I agree with that. So the same applies to these kids down in Texas whose parents came across the border illegally, but who are now here living in the country and need to go to school, need an education. They're not responsible for what the parents did. Yes, sir. Oh.
I appreciate your presenting both sides of the argument, and I think they were pretty comprehensive. But getting back to the Supreme Court or SCOTUS, on the hypothetical, what would you expect them to rule when it gets to them? And what do you think their reasoning would be, if you can go there?
Well, am I still being recorded?
Yep.
I automatically put Thomas with the Trump administration, and I put Alito there too. Kagan Jackson, also a former student of mine, but don't ask her about that. Kagan, Jackson, and Sotomayor, they're three who are going to uphold it. I mean, you can tell that from the transcript of the oral argument. I hope there's a majority. There's a majority to say the executive order is unconstitutional, and I guess I would put Comey Barrett in there. So that's 4, because this is what you have to do in the Supreme Court. You got to count. You got to get. I tell my students, you got to get to 5. So if my suspicions about Comey Barrett are right, that's 4. So you got to pick off. You got to pick off one more. And I don't know enough about what's his name, Gorsuch's or Kavanaugh's view on that, but I'll bet you Thomas and Alito, and we can bet the crab cake lunch I had today with anyone in the room, that they come down on the administration side. Now, Roberts, I don't know.
Am I next? I have a little slightly different take on Larry's question, and that is
Who's Harry?
Larry's the guy who
Larry.
had the long question. The multi.
I want to keep an eye on Larry and the other guys that give me complicated questions.
Mine is simple. What about the person who comes in here by plane and asks for political asylum? And they're following all the rules. They're legal. They're following the legal rules. Now, I will say the person I have in mind was picked up by ICE. I mean, that's a different issue. But are they considered, if they had a child here, would they be considered undocumented or illegal immigrants? Or are they sort of legal?
Well, documented could mean, as I believe this is Larry's question, could mean that they're following the rules, but they haven't been given permission to stay, or they overstay their rules. Somebody who's comes in here and asks for asylum, it depends on what happens. All right, if they put them in a detention camp, they're not supposed to be going anywhere, and if they escape, then they're in the country illegal. Now, they may not be undocumented because there may be some documentation about them, but they're in the country illegally if they leave that detention camp. Well, if they came in legally and asked for asylum and then they were released pending an asylum hearing, then they're documented, and they're not undocumented person. That's my understanding.
I think that's right.
my but they're not a citizen. They're a documented person the same way that somebody in here who comes here on a student visa or a travel visa or a business visa, those folks are documented, but they're not citizens. They're lawful, documented persons, but not citizens. Sure. Oh, you mean the city? Well, if their children came in? Oh, I see your question now. I'm sorry. If their children, if they had children, no, they would be considered, they would not be considered unlawful, undocumented persons. That's my understanding.
We have a question on the screen. Do you want to, I'll read it to you. This being the most conservative Supreme Court ever, at least in the modern era, don't they pride themselves on not reading things into constitutional or statutory provisions? They do not consider themselves activists. A literal reading of the constitutional amendment in plain English would clearly say, born here, jurisdiction here, you are a citizen. To go further and start reading things into the amendment, doesn't that conflict with the conservative philosophy to not do that? Don't they call it activism? A conservative no-no?
That didn't sound like a question. It sounds like a speech, which I agree with most of it.
Yeah. I'm going to follow up on that and ask my question, which is you began with this potential statute that Congress could pass a statute that says if you are undocumented, however we're going to define undocumented, you do not have citizenship, or your children do not have citizenship, would not have citizenship. And you equated that statute to the Indian Citizenship Act of 1924. And I want to push back on that and suggest that that Congress always has the authority to grant additional citizenship rights, but that they do not have the ability to take away citizenship rights that are granted in the Constitution.
Well,
And would the definition of that statute that you began with, wouldn't that be a potential detraction of the rights granted by the Constitution? And so Congress could not do that.
Two things. When I talked about that statute, I was talking about
Hypothetical statute, yeah.
hypothetical, and also what the Trump people said, look, Congress can use their Section 5 powers
Right.
to define who or who is not a citizen the same way they did in 1920, which was defining.
Yeah, but the Section 5 powers
I know. In Section 5, what Professor Ryder
are
discussed.
to enforce, not
Right. But
limit.
the Trump people would say to you, you're assuming a right that Supreme Court has not announced. Okay.
I'm going with the plain language.
Yeah, the plain language, yes, but the plain language only goes so far, because you accept that the children of diplomats are not part of that plain language, at least historically speaking, right?
Right.
So the plain language only goes so far. You're going to accept that at least in 1866, the Native Americans, despite being born, all right, they weren't part of it. And then the children of the occupying armies, plain language, they're born in the United States. And if we reverse the battle, they're subject to the jurisdiction of the United States. I mean, the only reason why we say the children of invading armies are not citizens is as a practical matter. We can't control them, but they're born in the United States, plain language. But you make also a very good point when you say Section 5. The argument Professor Ryder having is Congress can use its Section 5 powers as a one-way ratchet.
Correct.
They can expand rights, but they can't retract rights. And the argument would be, I take it, is that, well, this is a right that these undocumented children, or the children of undocumented persons have. Trump people say, you're assuming the question by saying they're citizens, and you're now trying to take that citizenship away from them. No, it's contested. Wong Kim Ark didn't say anything about the children of undocumented.
I think there was a brief period, and I'm not sure whether it was the 20s, and I guess Congress passed a law taking away the citizenship of an woman who married an alien. I have a vague recollection of the case. She didn't know she had lost her citizenship, and so she tried to get a passport to go to Europe and was denied because they said she had lost her U.S. citizenship when she married the alien.
I'm not familiar with that case. I'm not saying it doesn't exist, but yeah.
Okay, I wanted to follow up on the congressional action. What's the process that they would go through to push through interpretation of the 14th Amendment like this? And where would it go from there? Would they, I assume that it couldn't be, I mean, that the filibuster would have to take place. It would have to have at least 60 votes. So it probably would be challenging to get to. But, you know, these days, even though you didn't talk about it, but it seems like the protest in the courts would be through class action suits because there's no other way to get to the Supreme Court.
Well, I mean, you asked first what would be the process. It'd be the same process for any other statute that was proposed. It wouldn't look any different. You'd have a proposal, and each house would vote on it. And if there were a majority, then it would go to the president, and he'd sign it in a heartbeat. Now, you know, what it would look, how much support or opposition would exist causing a filibuster, I don't know. But the process would be no different from the process that's taken for any other statute. They would just be using, because see, one of the things students who come to law school don't understand, Congress only has the power to pass laws in areas that they've been given the power to. It's not like it's not like a state or local government. They can pass a law on anything they want. Congress has few and divided powers. Now, this is having to do with immigration and Section 5, as Professor Wright mentioned, but it would be like any other statute they would pass. They would just be using their powers under Section 5 of the Constitution as the constitutional hook to give it the authority. Does that answer your question?
Am I next? Am I being too much of a strict constructionist to ask whether the power to enforce a provision would allow them to change the first part of the amendment?
A little bit of a strict constructionist, yeah, you are.
Well, it seems to me that it's...
No, you're making the same point that the court had made in the 60s and 70s when Congress tried to diminish certain protections. And the Supreme Court, in a series of cases, dealing mostly with the Voting Rights Act, said that power that you're referring to acts like a ratchet. Congress can expand rights, they can't eliminate rights. Now, you know, as was argued by, some of you have heard of a guy named Jesse Helms from North Carolina. Well, in the 70s, some of us may remember that Jesse Helms tried to pass a human life statute, right? And his purpose was, of course, to overrule Roe v. Wade. All right. Is he still alive now?
No, he's gone.
He's not alive. Because he didn't get to live to see what happened in the Mississippi case. But Jesse Helms, they was told, he said, look, you can't do this because you're diminishing rights. Because he was using Section 5 to pass a human life statute. And his response was, well, no, I'm expanding rights because I'm protecting the rights of the fetus. Now, some people are sort of giggling at that, but that's not a crazy argument. It's not a crazy argument. And a similar argument was used when Jesse Helms and fellow travelers, all right, sought to reverse the Supreme Court's affirmative action cases. Now, again, they just needed to have a little bit more patience, and they would have gotten there with the court. But the argument was, well, we're gonna pass legislation, and some states did, like California and Michigan, that eliminate affirmative action. And the Democrats, the liberals said, oh, you can't do that. You're diminishing rights. And they're like, no, we're protecting the rights, we're enforcing the rights of white people. So you are being a little bit of strict construction.
How does it apply
which-
to this, the birthright issue?
Sorry?
How does this definition of enforcement apply to the
Well,
birthright
again,
issue?
it's the same response I have to Professor Wright. There is no precedent acknowledging that children born of undocumented persons are citizens. Wong Kim Ark did not hold that. It said the children of lawful aliens are citizens. The debate we're having, the debate Trump is having, is about children of unlawful, illegal aliens. It's a difference. Children, but they're not, legally speaking, they're not the same. Now, if I can digress real quickly, I was in the hallway back at my former place of employment, and a couple of my colleagues called me over. They were waiting for the elevator, and they said, Tracey, come see, because two of them had their babies with them, their infants with them. Tracey, come see the babies. I'm like, I'm on my way to lunch. I got things to do. I go, no, come see the babies. Come see the babies. So I walked over there and I said, what's the big deal? Babies are like M&Ms. They all look the same. They're just different colors. They didn't like that.
I think I may have missed this somewhere in the discussion or in general. Are they trying, what would be how would the overturning of birthright citizenship be if one parent was a citizen and one was not? Does that make you a citizen, or does that make you
That's
not
a great question.
citizen?
That question was asked. So I don't know whether you heard that discussion or not. That's a great question. And I don't know if the Trump executive order discusses that. I don't know, to be honest with you. When I looked at it, I don't remember that being, but no, that's one of the problems. That's one of the problems they would have trying to enforce this. And there are several problems. I mean, what are you going to do if the great state of New Jersey recognizes these kids as citizens of the state of New Jersey, but when they go apply for Social Security with the federal government says, no, you're not. And, what about driver's licenses and other sorts of things that are controlled by the state? And then what do? You say, well, they're not citizens, and you deport them along with their parents, and the home country won't take them. They say, well, they're not citizens of Guatemala. They were born in the United States. We don't want them. What do you do then? So there are a lot of unanswered questions that, if we were strict constructionists, could be easy. Said, no, you're born in the United States, you're subject to jurisdiction, period. You're a citizen. But this is all political. We know this is not. You don't need to be Ehrlich Bailey to know that this is not about the Constitution. Trump doesn't care about the Constitution. This is all political. All right? Now, see, you got me ginned up here, and now I'm telling you my view. This is all political. Trump doesn't care about the Constitution.
Okay, well,
Please. Right?
I think I have a real simple question for you. How does the average person prove they're an American citizen? Now, you can look at the birth record, but I've delivered a lot of kids and I've filled out a lot of them. I've never put down whether the mother or the father is a citizen. It's just who they are. So if ICE or Gestapo comes to me, I can't prove that I'm a citizen. I don't have an identity card like some
They
countries
would say it's
do.
up to you to prove it.
Well, but how do I do that?
You
Before
might
they
be in
send
trouble.
off to El Salvador.
Right. No, again, another good question. But they're going to say to you, it's not our job to prove your citizenship. I'm sorry? Well, you don't have a birth certificate? Okay, well, there you go. Say that again? No, no. So again, look, you're preaching to the converted, sir. No, I take that back. You're right. That's not under the Trump scheme. That would not be proof. You'd need more than that. Right. You wouldn't get it if your parents, under the Trump scheme, if I'm understanding it correctly, and I think I am, the amount of duration that you've been in the country, the fact that you married an American, the fact that you held a job, the fact that you served in the military, none of that would matter. Like I said, either you're in from the get-go or you're not.
Your parents would have had to have been citizens,
Yeah, but
legal immigrants.
Right, but the premise of your question is your parents, assuming your parents came into the country illegally, right? Well, I understand that, but let's assume let's assume they came into the country illegally. Let's assume they were criminals, right? I'm not going to say the apple doesn't fall far from the tree, but let's just assume, all right, that they were criminals. It would be up to you to prove, but I'm sorry. If they came into the country illegally, you could not become a citizen. Period. Right? I mean, that's why Professor Wright is here to fact check me and keep me in.
I'm doing my best. One
By
more
the way,
question,
I
and
would
then I think we're about
I would vouch for him.
You would?
For Joe.
Wait, now, where's your proof of citizenship?
Yeah. Well, he'll vouch for me.
Oh, well, that's not gonna, then you're gonna talk about Larry vouching for him, and I don't know if I'm gonna go that
I don't know about Larry. Question.
I got, they may not be citizens, but I got dogs at home, so.
Yeah, I know,
Yeah,
right?
the last one.
Right. Question. Trump constantly says that we're the only country that allows what we allow. And I was just
And
wondering
we're
if that's,
suckers. We're
I was
suckers.
wondering if that's true or not. Are there other countries that automatically give birthright or have birthright citizenship to? Do you have any idea if he's accurate or not?
Have you heard of Clint Eastwood?
What's that?
Clint Eastwood, you know who Clint Eastwood is?
Sure.
Yeah, you know the Dirty Harry movies?
Sure.
And you remember his line, "A man's got to know his limitations"? I take that into heart. I can't speak to that. I don't know. I'm sure there are some countries, but I'm a guy from New Jersey who knows the American Constitution, and that's it. I know my limitations.
33. There we go.
Power of AI. Thank you very
Well,
much. I
thank
hope it
you
was
all
informative.
for coming, and thank you, Tracey. And next week, we have Chris Mullins from the Lumina Foundation.